Hello students, let us discuss the next question now. This question is from 2020. In India, the separation of judiciary from the executive is enjoined by option A, the preamble, option B, DPSPs, option C, the 7th schedule, and option D, conventional practice. Now let us look at how we would solve this question in the exam. Now recall, what does the preamble talk about? The preamble has the overall objective of the constitution as the constitutional makers viewed India to be. The DPSPs have some instructions to the government, certain mandates which the government has to follow when they are making the laws. These principles have to be followed by the state. And if you recall, the 7th schedule has the 3 lists: the union list, the state list, and the concurrent list, dividing the powers between the central government and the state government. And there are certain parliamentary practices also, even though if they are not mentioned in the constitution or the rules of procedure of both the houses, we still follow it due to convention. Now this question is asking the provision of separation of judiciary from the executive. Where is it mentioned? Is it there in the preamble, or is it there in the DPSPs, or is it there in the 7th schedule, or it is due to a conventional practice? So it is not there in the preamble, and it is there in the DPSPs, and it is also not there in the 7th schedule because we know it is the lists which are there, and definitely it is not the conventional practice. So the correct answer for this question is DPSPs. Now let us go into the in-depth provisions of DPSPs. The DPSPs in the constitution are mentioned in the part 4 from the articles 36 to 51. And what are the directive principles of state policy? As the name itself has it, these are the principles, the policies which the government should follow when they are making the policies and laws. And they were borrowed from the Irish constitution, which was earlier adopted from the Spanish constitution. They also resemble the instrument of instructions which were there in the Government of India Act 1935. Ultimately, following DPSPs will lead and make India into a socio-economic democracy, because in the Article 37 there are very clear provisions that these principles have to be followed by the state in the governance of the country, and it is the duty of the state to apply this in the policy making. And if you also recall, ultimately following the DPSPs will lead to a welfare state, and they are not justiciable. That is, if the government is not following them, we cannot go to the court to enforce them, unlike the fundamental rights. So now coming to the very statement that was there in the question. The statement was separation of judiciary from the executive. And if you look at Article 50, Article 50 talks about separation of judiciary from the executive. This Article 50 also comes under the DPSPs. The provisions very clearly state that the state shall take steps to separate the judiciary from the executive in the public services of the state. So clearly the answer is DPSP. Now, how do you remember this? For this, you can use the trick. Remember 50-50. So 50-50 is like dividing. So separation of powers come in the Article 50. So remember this 50-50, separation of powers. Now the concept of separation of power, that was given by Montesquieu. So Montesquieu says that the powers of a government is divided into 3 different branches: the legislature, the executive, and the judiciary. And why are the powers divided? So that ultimately no single branch should have so much power that it will act as a absolute power. So that is why the powers are divided among different branches, so that they can balance on each other, so that ultimately the checks and balances can be put on the powers. And so clearly the powers have been demarcated into 3 different organs. And sometimes the division is absolute, wherein one organ cannot overstep into the powers of the other organ, but sometimes the division is not very clear. The powers will slightly overlap. And here we should recall the statement of Montesquieu, where he said that there is no liberty if the powers of judging are not separated from the legislative and the executive. Because now imagine a scenario where the executive officer only also has the judicial powers. So do you think the judgment is going to be completely independent and objective? No. We being human beings ultimately our subjective opinions and our subjectivity comes into play. So you cannot be a judge in your own case. Similarly, if you have the powers to execution and you also have the powers to judge, that you won't be objective, you won't be independent. The independence of mind won't be there. So you will be partial. That is why we need to separate the powers. So Montesquieu said that how we related the separation of powers concept to liberty. So in future you might get a question saying that even the concept of liberty comes out of the separation of powers, or separation of powers is related to the concept of liberty. It is true, because without separation of powers, a power will be there in a single person and he may not be acting very objectively. He'll be very subjective. In that case, it will affect the liberty of the people whom he is judging. So that's why Montesquieu said there is no liberty if the powers of judging are not separated from the legislative and the executive. So coming back to our question, in India, the separation of powers from the executive is enjoined by the directive principles of state policy. Thank you.